Hey there, YouTubers. Today I wanted to go over a little known Hawaii revised statute. It's the basic rule for speeding. It goes over the elements of what needs to be proven in court in order for conviction. Most people don't know this. They think that just because they got a speeding ticket, they were going to, 55 and a 45, that they were speeding, and they don't fight the ticket. This is a very easy one to actually beat. Um, I'd also like to start out by saying that I am not an attorney and this is not legal advice. So if you're in trouble for uh, violating some traffic infraction here in Hawaii, I would suggest to research this stuff for yourself and don't go by what I say, or get yourself an attorney. Um, but yeah, let's just go ahead and go over this. This is 291c-101, basic rule for speeding. Okay, and no person shall drive a vehicle at a speed greater than is reasonable and prudent in having regard to the actual and potential hazards and conditions then existing. Consistent with the foregoing, every person shall drive at a safe and appropriate speed when approaching and crossing an intersection or railroad grade crossing, when approaching and going around a curve, when approaching a hill crest, when traveling upon any narrow and winding roadway, when special hazards exist with respect to pedestrians or other traffic, or by reason of weather or highway conditions. So these here are basically all examples of what may be unreasonable and not prudent. Okay, so these are facts. All right, facts are different than opinions when it comes into court, and according to the case notes here, this is where it gets interesting. For conviction, there must be evidence that the speed was unreasonable under the actual and potential hazards and conditions then existing. All right, those are the case notes. So, in order for there to be a conviction, there has to be evidence. Okay, this here, winding roadways, special hazards exist with respect to pedestrians and other traffic. If you're going around a curve, approaching an intersection, those are all facts. Okay, if they have not presented any facts and it's basically just opinion, obviously they can't get a conviction because there has to be evidence. All right, and it can't just be the officer saying, "Oh, I think he was going too fast and he could the driver could hurt somebody." That's an opinion. That's not fact, and you can object to that and have that testimony tossed. So yeah, I just wanted to go over this with everybody. Speeding tickets are probably one of the easiest ones to beat here in Hawaii. It basically, once the judge, in the beginning here in Hawaii, we have what's called a contested hearing. It's no prosecutor. The prosecutor just basically stands there and doesn't do anything. It's a judge that acts on behalf of the prosecution and the jury. And the judge will just read the complaint and then ask you how you plead to it. And at that point, you say, has the state rest its case? And the judge would say yes at this point. And then you would just object and ask for a dismissal because the prosecution failed to place evidence that the speed was unreasonable under the actual and potential hazards. And they'll have to drop the case, period. The prosecution can't add anything to the complaint because they're not a fact witness. And once the prosecution has also rested their case, they can't add any more evidence at that point. And like I said, it has to be evidence. Not just a radar saying that you're going 55 and a 45. You know, sure, you're going over the posted speed limit, but there's no evidence that the speed was unreasonable under the actual and potential hazards. So yeah, everybody go ahead and take a look at this, research this for yourself. Like I said, this is just the U.S. law, and you can find it basically by just typing in Hawaii Revised Statutes 291c-101 basic rule. All right, I hope this helps, and if you have any questions, please feel free to message me. Thanks for watching.